Hey, what's going on? This is Instructor Mike. All right, don't forget to hit that subscribe button, hit the bell for notifications on all of your platforms. Let's go on ahead and dive right into it. So, the Illinois U.S. District Court of the Southern District of Illinois refused, I don't want to say refused, but the judge decided to deny the plaintiff's motion for a preliminary injunction to halt the January 1st deadline for the PICA, the Assault Weapons Ban and Magazines Ban of Illinois. Let's go ahead and talk about it. Here we go. Again, shouts out to Bishop on Air. You can go to follow his page, Bishop on Air. Let's go ahead and talk about it because I had some opinions about this, the rush that people had regarding filing the various claims for parts and think, look, I'm not a lawyer. I'm not going to even claim to be one, whatever the case may be. And again, this is not legal advice, but I do, as a firearms instructor, a criminal justice lecturer, a former cop, veteran, all that great stuff, the culmination, if you will, or the accumulation, whatever term, of my total education experience and understanding of these things. I'm going to give you the perspective that I have from this and say, I agree with the judge. I agree with the judge. Let's go on ahead and look at it. So we're going to go on ahead and look at Center Square. And I know this is not going to be popular for some of you all and stuff like that. But let's go on ahead and look at what the judge was saying in this. Let's go on ahead and look at that. Let me just get the right screen up there. There we go. All right. So getting to this, and this is Center Square by Greg Bishop of Center Square. You can go on ahead and again follow him on Greg Bishop on Air. He does an outstanding job talking about this. So vowing to address the merits, the judge won't block January 1st gun registration deadline. And yeah, I'm going to read some parts of this and then we'll have our discussion. Here we go. The deadline for Illinois' gun ban registry remains in effect after a federal judge denied an effort to delay the January 1st deadline. Federal Judge Stephen McGlynn granted the state's motion to dismiss the preliminary actions, but without prejudice. Okay, which means without prejudice means they can file again if they so choose. With prejudice means they can't file it again. Urging for the court to address the merits of the challenge, and this I wholeheartedly agree. Earlier this month in the Southern District of Illinois, McGlynn heard the case of the federal firearm licensees of Illinois and other groups seeking a temporary suspension of the state's January 1st deadline to register banned firearms to the Illinois State Police. Okay. In a ruling Friday, McGlynn denied the plaintiffs' groups standing and dismissed their due process and vagueness arguments against the gun ban registry. While denying the preliminary action to block the January 1st deadline, McGlynn reasoned that such action, quote, may also create further delays in this litigation when the constitutional rights of the citizens demand an expeditious resolution on the merits. I wholeheartedly agree. I think this was one of those, let's throw something against the wall and let's see if it stick. You know, when I was hearing people filing these different, I'm just like, you guys are just trying anything. And don't get me wrong, I'm all for trying anything. But at some point in time, the continuous litigation could just convolute a easy issue that people just don't have patience on. They just don't have patience for the process. And I get it, right? They don't have patience for the process. But let's continue. Illinois banned the sale and possession of more than 170 semi-automatic firearms and magazines over certain capacities, that being 15 rounds or more than 15 rounds. The law included a registration for who's possessed banned items from before the January 10th, 2023 enactment date. Being found with unregistered banned items could lead to criminal penalties, including a Class 3 felony for the second and subsequent offense after January 1st, 2024. While the original case has already gone up to the appeals court on the preliminary injunction, FFL of Illinois and other plaintiffs amend their complaint back in the district court to argue due process violations, and they wanted that January 1st deadline to be delayed while the cases against the state law continues on the merits. McGlynn on Friday noted that the state's argument against a preliminary injunction was because the plaintiffs are continuing appeals on the earlier question. Quote, the government, I'm going to highlight this too, the government argues that the Seventh Circuit has already held that such a claim is unlikely to succeed on the merits. And this is the government arguing this. Citing the reporter from the Center Square, McGlynn said the FFL plaintiffs do not allege that specific individuals did not have notice of the requirements. They only argue that the Illinois government did not give adequate notice to the public, as evidenced by the number of FOIA card holders who have filed endorsement affidavits. And I'm going to say that's flat out wrong, respectfully. They actually gave the proper notice. They gave a lot of notice, actually. And we got to be careful when we make these arguments, because you're stating the state didn't give proper notice. Yes, they did. They gave proper notice, right? We're just throwing something against the wall to see if it sticks. Now, who am I? I am probably no one that any of you have to listen to. I'm just offering my perspective on this channel, okay? Let's go. While McGlynn dismissed the due process claims and that the FFL and other plaintiffs lack standing, the court would address their arguments on the merit in order to develop adequately develop the record. And I think this is important. If you're not a lawyer, and I'm not a lawyer, right? But I understand a lot of things about the law because, one, I research, I ask questions, right? And we don't want to convolute the record of such a thing that could be so simply addressed on the merits. If we are going to say that the state is violating that the new law in place in light of the decision of New York State Rifle and Pistol Association versus Bruin, right? In light of NRA v. Chicago, in light of Ezell and Ezell 2, in light of DC versus Heller, or Heller versus DC, in light of these cases that have led, the Bruin case especially, if we're to state that this and the other bans in other states violate the recent decision in Bruin, what are we gonna really get by convoluting the issue with other things, talking about parts? I heard in one hearing we're talking about Star Wars, and it was just all over the place, right? So we don't want to convolute the issue. Here we go. Let's get back to it. Sorry about that. The January 1st, well, apparently here are the 29 coolest gifts of 2023. We want to move this out the way. Got it. The January 1st deadline does not by itself cause criminal penalties to automatically attach an issue. Rather, the government must prove that the individual in question knowingly possesses the item in question. This I wholeheartedly agree with. I appeared on Bishop on Air, and I was talking with Greg Bishop. Again, he does an outstanding job. If you are not following his page, you are missing out so much, because I love how he is just on top of it and just keeping up with it constantly. So please go follow him. But they were asking, he was asking me a question about leads, the law enforcement agency's data system, the mobile data terminal in the car and stuff like that. And how would the state police or other Illinois law enforcement agencies even get access to this information? I said, it's not going to be that easy. First of all, when you go purchase a rifle or any type of pistol or semi-automatic firearm or so-called assault weapons, whatever the case may be, outside of having to get a tax stamp for your different types of firearms that fall in line with the federal gun laws and stuff like that, you have to fill out an ATF form 4473. It's a paper form. Well, now it might be digital because it's on computer, depending upon where you purchase your firearm. And that information, you fill out certain things and ask certain questions, just your biographical and, location information and stuff like that, and just answer these questions. And then you sign certifying that you are the one that's going to be purchasing this firearm, and you are affirming that, you're not addicted to drugs or whatever the case may be that they ask you. And that you're not dishonorably discharged, you understand. But when it comes down to the make, model, serial number of the pistol or rifle or whatever the firearm is that's regulated, triggering you filling out that form, the gun dealership fills out that form. And then they do the check to the state police. It's a pistol, rifle, shotgun, stuff like that. And then that information is shared between the ATF, Bureau of Alcohol, Tobacco, Firearms, and Explosives, and the gun dealership, in terms of whatever it may be. I don't know if the computer information goes directly to them. I know the paperwork is on file. The check is done through the Illinois State Police, but I don't think they get the make, model, and serial number of the firearm or firearms you purchase. I think it's just what type of firearm you're purchasing and your information, so that way they can approve the transaction with the state background and federal background check. Neither here nor there. The computerized law enforcement agency's data system, that stuff has to be manually entered into the system. It's not automatic. That stuff has to be manually entered into the system. So just imagine how many gun owners you actually have in the state of Illinois, and all of those previous firearm purchases, not your recent ones, the previous. There's no telling how long people have been owning pistols or rifles, so-called assault rifles, magazines, which are not really recorded purchases. Magazines are not recorded purchases. You hear what I said? Magazines are not recorded purchases. So how does that information just magically pop up in the law enforcement agency's data system? Knock, knock, knock. It doesn't. That stuff has to be manually entered. Warrants have to be entered by clerks. This information has to be entered into the system by clerks. So here's what happens. You get your standard traffic stop, 45, I'll be down to traffic stop, Central and Main, Illinois 28, 489, David 385, 489, David 385, one occupant, code 3. Out of the car, get outside the car, approach the vehicle. You know the reason why I pulled you over because you were speeding. Oh, I wasn't? Yes, you was. Got it. Not going to argue with you. Can I get your driver's license, proof of insurance? Got it. 435, 27 by 5 when you're ready. 27 is just a 10 code, and different law enforcement agencies do it different. 435, go ahead. David 489 3758 4875. Blah, 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 blah. You repeat it twice. It comes back. 435. 27 is clear and valid to such and such John Doe out of Springfield. No 29s attached. I'm strike that. 29 is clear, which is just your wanted stuff like that. If it's information where a person has a warrant, 435, you clear for 43. Are you clear for information? Back off. You get your distance so that you're out of earshot. Yeah, I'm clear. 27 that's attached to John Doe. The 27 is clear and valid out of Springfield, Illinois. Subject is 99 out of Chicago, means he's wanted out of Chicago. And then we get that information, and I'm giving you the scenario so you can understand what would lead us to a search of the vehicle, right? So we go ahead. Mr. Doe, can you step outside of the car for me, please? Step outside of the car. Hey, do me a favor, turn around. Click, click. Okay, you got a warrant out of Chicago. Secure you in the car. And that's a nice traffic stop, right? So we secure you in the car, do a search of the car, incident to arrest, because we have to impound the car. And then once we impound the car, and things might have changed because of the Safety Act, right? Warrant to notice to appear, whatever, but who knows, right? But I'm just giving you a typical scenario as I remember law enforcement to be. Take you into custody, and then impound the vehicle. Once we begin to go through the vehicle, let's just say we find one of these so-called assault rifles, right? Then we go on ahead and run it. Now, you can run a rifle or any type of pistol into leads to see if it's been reported as stolen, entered into the system as stolen, whatever the case may be. And here's what I would imagine. I would imagine that those who have registered, that information is populated into leads, because all it is a computer, right? It could be on a spreadsheet, it could be whatever the case may be. That stuff is populated into leads. So that way, if you have a registered firearm, it appears as though this thing that you have has been registered. But if you have a so-called assault rifle or some type of banned object, and they run it, name, make, model, serial number, and they have that rifle or whatever you have among the list of the 170 banned rifles or magazines or whatever, the fact that you did not register and it's not in the system as having been registered, would then trigger whatever process would determine, because then they would have the proof, as Judge McGlynn said, to be able to assert that you did not register that particular thing. So I think that when people don't understand, like you can read and comprehend, but when people don't understand, it creates a fear. And then you begin to file these different cases based off the fears of what you don't understand. And it doesn't help that the lawyers are not really explaining, look, Tim, I know you're in a rush to do this. You know, this is not going to really win on the merits. You know, it's just wasting time. It's wasting time. I did a video a while back, and I'm gonna get to this thing in a minute. I did a video a while back as soon as the law was passed. Check out my TikTok. Yes, Mike said it. As soon as the law was passed, I did a video and I said, buckle your seatbelts. You're going to be waiting 2 years. How many of you all follow me and remember me saying that? Buckle your seatbelt. You're going to be waiting for 2 years. If you look at the case history of New York State Rifle and Pistol Association versus Bruin, from the time the case was, the law was enacted to the time New York State Rifle and Pistol Association versus Bruin, and that wasn't even the original name of the case because the director of the state police had changed hands from the last person to Director Bruin, right? By the time the case had came out, it was 2 years later, approximately, or more than 2 years later. Illinois, we're not special. We're not, right? And why do I say that? Remember the situation with Associate Justice Amy Coney Barrett? Oh, well, we were hoping she was going to come through. No, why would she come through for Illinois? Because look at the doctrine of stare decisis, which is to stay the decision or the actions of the previous court decision. If the Supreme Court of the United States starts making a special case for Illinois because of what we in the state determined to be a emergency, right? What's the saying? An emergency on your part does not, or the failure to plan on your part, that's the statement. The failure to plan on your part does not constitute an emergency on mine. Got it. Okay. So the emergency that you think you may have may not be necessarily an emergency for us. And under Immanuel Kant's categorical imperative, do we want to create a action that we would will to be universal law, that everyone with their emergency can then seek emergency redress from the courts, and bam, just like that, they're going to go on ahead and preliminary injunctions for everybody and everything? No, you're not special, Illinois. You have to wait the process out. Let's continue. And here I am saying, I'm a fair person. I try to ride the middle. I'm not conservative or liberal. I'm not Republican or Democrat. I'm independent. I analyze these things on the merits, just like Judge McGlynn did. Let's go on ahead and look at this again. Here we go. The January 1st deadline does not by itself cause criminal penalties to automatically attach an issue. Agreed, 1000%. Rather, the government must prove that the individual in question knowingly possesses the item in question. I'm going to highlight this. Knowingly possesses the item in question. How are they going to prove it? How are they going to prove it? How are they going to prove you knowingly possess the item in question? Here we go. On the vagueness arguments, the judge said the rules the state has published so far were not, quote, unconstitutionally vague. And I got to agree with that. They were not unconstitutionally vague. You created an emergency alleging what was not. It's not unconstitutionally vague. It is as it stands. And the state police already said in the hearings that, by the way, Greg Bishop did an outstanding job putting that stuff on. You got to go follow his page, right? You got to go follow his page. The state police said you don't have to register magazines. Who said that? They never said you had to register magazines. That's not in the portal, right? You don't have to register magazines. They're not asking that. It's a certain way you possess those magazines if you got them grandfathered in, whatever the case may be. You can't purchase new ones, right? But you don't have to put that in the portal. Stop being hypochondriacs and making up stuff to convolute the issue. The matter is on its way up to the Supreme Court of the United States. Stop convoluting the issue. It's not going to happen. Bruin didn't happen that fast. So this is not going to happen that fast. I mean, let's look at first-degree murder, 720 ILCS 5, Section 9-1, right? Person commits the offense of first-degree murder, right? They're arrested. As soon as you have enough probable cause to arrest, felony review approves case. How long does it take to get the trial? The arrest is always quick. The trial, 1-2 years later? The court system does not move fast. And they're not moving fast because you think your constitutional rights have been violated. And we know they have, right? But it takes the time to get to there. Come on, you guys, let's go. All right, let's get back to it. Here we go. Rather, they are clear. Let me read this again. On the vagueness arguments, the judge said the rules the state has published so far were not unconstitutionally vague. Quote, rather, they are clear in what they prohibit. Serious issues with the Second Amendment aside, the emergency rules and PICA more generally may well be unconstitutional as determined in the court's review on the merits. However, they're not vague, and they're not. They're so clear, right? While they may very well be determined to be unconstitutional in an as-applied challenge on the merits and in a trial setting after discovery has been completed, the FFL plaintiffs cannot plausibly allege that they are facially void at this stage in litigation. I agree. 1,000%, right? McGlynn, and I didn't want to say anything. I wanted to wait till that decision came out, right? McGlynn said he's interpreting the Seventh Circuit U.S. Court of Appeals ruling in November, reversing his initial preliminary injunction as directing the lower courts to advance the merits review of all the claims. So let's play this out. Right? He goes on ahead. He grants the preliminary injunction. Guess what the Seventh Circuit's going to do? Reverse it. So why are we convoluting the issue? You already know what's going to happen in this process. It's already going to advance to the Supreme Court. Let the process do its job. And the problem is when people don't understand process, right? When people don't understand process, they become impatient. Right? And the lawyers, God bless their hearts, right? They're just doing what their clients are paying them and asking them to do. Let's throw it and see if it sticks on parts. Come on, it's not vague. It's already unconstitutional. Let it take its course. Bruin took 2 years or more. This is not going to rush because Illinois is special. We're not special. We're just being violated, but we're not special, right? California just had what? May v. Bonta v. May, right? The district judge did what he did. Ninth Circuit's going to do what they do. It has to make it to the Supreme Court of the United States. And I give Justice Amy Coney Barrett honor in saying, look, great job for suppressing Illinois and saying, hey, sit it on down and let this case take the usual route that every other case has to take. You already know there's a high likelihood we are going to grant certiorari. On the writ of certiorari, we're going to probably grant it. You already know that. Stop it. Just let it take its course. You're doing too much. Okay? So that's just my opinion on that. Here we go. I got to read the rest of this too because it's important. He said, in the weeks ahead, McGlynn noted things could develop. Initially, Illinois FOIA card holders' level of compliance registration will be discernible within the mere days, he wrote. This overall compliance will likely be highly relevant to the review of certain claims on the merits, right? McGlynn noted as of the date of that order, 8,143 individuals out of 2,413,481 Illinois FOIA card holders, that's 0.34%, right, or 34/100th, you get what I'm saying, of a percent, have submitted affidavits. And I'm in Cook County. I'm going to submit mine. I've already said I'm going to do that. I probably didn't get the screen bigger. I'm sorry. You didn't even see that. But I'm going to submit mine because I'm in Cook County. And here's this. You don't have to agree. I don't care. You don't live where I do. You don't have to worry about Sheriff Tom Dart. I appeared on Bishop on Air and said I cannot in good conscience recommend that people in Cook County not register their stuff. Why? Because Cook County, they definitely going to get you. Chicago definitely gonna get you for sure. Because Cook County already said they would enforce. Chicago is definitely going to enforce. The politics in Cook County, you know they going. That's where this stuff originated out of, right? Springfield, Illinois, Springfield and Chicago, you already know. So I can't in good conscience say, oh, don't register. You do what you feel you can afford. Now, the rest of you all, you live in a gun-supporting county with gun-supporting sheriffs and gun-supporting and Second Amendment supporting states attorneys. Hats off to you. The rest of us that have to live in Illinois, you know, you get what I'm saying, right? You get what I'm saying. I got to read this part. Friday's ruling also had McGlynn discuss the role of the government. The government exists to serve us, not lord over us, McGlynn wrote. Quote, the Constitution places limits on the government's power while guaranteeing freedom and liberty to the people. The Second Amendment guarantees are fundamental and belong to the citizens. The Second Amendment acknowledges a right of the people, not a license to be issued or denied by the government as it sees fit. And before issuing the order denying the plaintiff's preliminary injunction and granting the state's motion to dismiss the notice and vagueness claims, McGlynn said on the merits, he will, quote, endeavor to faithfully apply, end quote, a previous U.S. Supreme Court precedent on the Second Amendment. Quote, any entreaties, hope I said that right, to ignore, erode, or infringe on the constitutional rights of the people will not gain traction in this court, Judge McGlynn wrote. I gotta give him credit for that. I gotta give him credit for that. I have to. I gotta give him credit for that because that's amazing that he is going to take that stand on the merits, and not this stuff that's just gonna convolute the issue, right? I get it. You want it to happen fast, but if you've been following me, you know I told you, baby, ain't nothing fast about the court when it come down to stuff like this. Not even in a criminal case. So if it don't happen in a criminal case, civil case, you get what I'm saying, right? There are some differences, but it's not going to happen that fast. All right, sign up in the comments. What are your thoughts? Shouts out to Bishop on Air and Greg Bishop. He does an amazing job. I followed him, subscribed to his channel. Anytime his stuff pops up, I am there. I am listening to the conversation. I am a lifelong learner. I love learning from other people, so I appreciate him and his journalism. I remember before he left where he was, WMAY in Springfield, I was following him then, right? I appreciate his stuff that he was doing. Very informational, and he, along with others, Gun Owners of Illinois, the Illinois State Rifle and Pistol Association, Chicago Guns Matter, Rhonda Ezell, and Corey Brooks, and a lot of other people. Freedom Steel, go follow Freedom Steel, his YouTube page, Todd Vandermine, you know, a lot of the people who are on the front lines in this fight, that stuff matters. That stuff absolutely matters because let's talk facts. I don't know too many black folks doing it. I gotta be honest about this shit. I don't know too many black folks on the front lines. And hey, people got to be careful with their arguments but not for other people fighting for the rights to be able to have, you know, our firearms and stuff like that. I don't know what we would do. I don't know if you got a Johnny Cochran of the Second Amendment that's black that could mount look, hats off to you guys, right? So I'm just doing my part in trying to provide my opinion and provide just a little clarity on what I think. And I agree with Judge McGlynn. I agree. I just always believe that was just throwing stuff on the wall, trying to see what's going to make it stick. Look, let it take its process, right? And I know you got to approach the Supreme Court through many avenues. So I can appreciate the throwing stuff to the wall to make it stick so that one of the cases makes where it needs to make, because, you know, it's like when state's attorneys charge a lot of charges just to make sure they get you on one and they may drop the rest. I get it. But I agree with this decision. Okay. So what do you think you're going to do when it comes down to the January 1st deadline? If you live in a county where they are not going to make it an enforcement priority, good on you, right? Good for you, right? The Second Amendment, you know, showing that the rights of the people to keep and bear arms shall not be infringed. But if you live in a county like ours, where they seek to heavily infringe after creating the conditions that make it ripe for candidates of criminal behavior, and they've had a history of doing that for quite a long time. Then they want to take away your rights to be able to protect yourself. It's very strange. All right, y'all. Don't forget to hit that like, comment, subscribe button. What are your thoughts? Sound off in the comments. This also is going to be on my podcast. The audio version of it is going to be on my podcast, On the Mic with Mike. I'm going to bring that back up again. I can't wait. I hope you all have a wonderful holiday. 2023 has been so good to me. I have learned so much. I have a lot to be thankful for. I have you to be thankful for. I love you guys. I am so serious. Whether you agree or disagree, it's all good. Look, family matters. Hug your loved ones. Hug yourself. Give yourself grace, right? And do what you have to do to protect yourself and your families, okay? This is Instructor Mike. You've been trained. Follow me on my various social media platforms. I'm out of here. Till next time. It's no one's job to freaking protect you but you. So you better get your doggone self in somebody's concealed carry course and get your doggone self in somebody else's additional training, because, there's so much we got to talk about. So much we got to talk about, okay? Please consider joining this channel. Please consider joining this channel. I drop new material all the time. It's in the members only section. It's in the members only section. So join on YouTube, okay? Other than that, this is Instructor Mike. You've been trained. Take care.